Presenting before you the legal updates for today live from the Honorable Supreme Court of India. In Dr. Balram Singh versus Union of India and others, the Supreme Court has issued directions to ban manual scavenging in 6 metropolitan cities, namely Delhi, Mumbai, Chennai, Kolkata, Bengaluru and Hyderabad, in a writ petition that seeks the eradication of manual scavenging in India. In its order, the court noted that the comprehensive affidavit submitted by the union lacked clarity regarding the eradication of manual scavenging and sewer cleaning. Furthermore, the order instructed the chief executive officer or the equivalent authority in each city of these metropolitan areas to submit a detailed affidavit specifying the measures taken to cease manual scavenging and sewer cleaning, along with a timeline for implementation. The affidavit must be filed no later than February 13. In Deen Dayal Tiwari versus the State of Uttar Pradesh, the Supreme Court recently upheld the conviction of a man for murdering his wife and 4 minor daughters but commuted his death sentence to life imprisonment without remission. The court cited the absence of prior criminal records, positive prison reports indicating reform potential, and established legal precedents discouraging the death penalty in multiple murder cases. The court emphasized that even in cases involving multiple homicides, the death penalty should not be imposed if the convict demonstrates the possibility of reformation supported by mitigating factors such as age, lack of criminal history, and socio-economic background. Referring to settled jurisprudence, the court reiterated that capital punishment is an exception rather than the rule. It observed that even in cases of multiple murders, if there is evidence or a reasonable likelihood of rehabilitation, a lesser sentence must be preferred. A bench comprising Justices Vikram Nath, Sanjay Karol, and Sandeep Mehta heard the appeal, where the accused had been convicted based on circumstantial evidence. Both the trial court and the High Court had sentenced him to death. Challenging this verdict, the appellant argued that the case did not meet the rarest of rare threshold required for the imposition of the death penalty. The court examined whether the brutal murder of his entire family qualified as a rarest of rare case warranting capital punishment. Concluding in the negative, it held that the case did not meet the criteria laid down in Bachchan Singh versus State of Punjab 1980, which mandates that the death penalty be imposed only in exceptionally grave circumstances. As per Bachchan Singh, a case falls under the rarest of rare category when first, the crime is excessively brutal, grotesque, diabolical, or shocking to the collective conscience of the society. Second, the act demonstrates extreme depravity or inhumanity, such as mass killings, heinous sexual offenses followed by the murder or the murder of law enforcement officers. Third, the convict shows no possibility of reform, making life imprisonment inadequate to serve the interests of justice. The court emphasized that before categorizing a case as rarest of rare, factors such as the motive, execution, severity of the offense, and the convict's potential for rehabilitation must be carefully assessed. If there exists any possibility of reformation, life imprisonment should be preferred over the death penalty. In X and Y versus State of Rajasthan and others, highlighting the urgent need for central and state governments to enact legislation regulating live-in relationships, the Jaipur bench of the Rajasthan High Court on Wednesday ruled that until such a law is enacted, live-in relationships must be registered with a government-established authority or tribunal. The court further instructed that until legislation is enacted by both the central and state governments, a statutory scheme must be formulated in a legally structured format. The court has directed the appropriate authority to prepare a standardized format that couples or partners intending to enter into a live-in relationship must complete before doing so. This format shall include the following terms and conditions. Number 1. Establishing the responsibilities of both male and female partners regarding a child plan, ensuring accountability for the education, healthcare, and overall upbringing of any children born from the relationship. Second, defining the male partner's obligation to provide maintenance for a non-earning female partner residing in the relationship, as well as for any children born from such a union. The court further stated that Parliament and state legislatures must consider enacting appropriate legislation or amending existing laws to ensure that couples in such relationships do not face harm or threats from their families, relatives, or society at large. It also observed that in many instances, female partners in such relationships suffer when the relationship ends. The court emphasized that this should not occur and that children born from such relationships must be protected, even if the relationship does not qualify as one in the nature of marriage. That was it for today. We hope you liked the video. Thanks for watching. For more such interesting legal updates, do keep following us. Till then, stay curious, stay legal.